The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody. This is Attorney Bernard Wolfsdorf. I'm an immigration lawyer sitting in beautiful Los Angeles, and welcome today to our immigration webinar. We have a really good attendance, so we're thrilled to at least meet you online. Today's immigration webinar will basically focus on investor options, primarily with the E-visa, the treaty investor visa. We will also deal with the company transfer visa and the green card options for managerial transferees, as well as touch on the topic of EB-5 investors, the very hot EB-5 investor program. We're not going to get into any depth on any of these issues. We've got basically an hour, and during that time I'm going to treat this as a program primarily for entry level. I do understand that some of you are very, very experienced. In fact, I've had a chance to review the audience, and it seems that we have some very, very knowledgeable and experienced individuals. For those of you who wish to ask questions, I'm hoping to be able to answer all your questions near the end of the program, so please use your chat function to ask questions. Please do feel comfortable to get online and chat with us and offer your questions, and I'll try and answer all of them. Just for some of the general information that we have, again, this is the Wolfsdorf Immigration Law Firm. This is not deemed to be legal advice, but merely an overview of the options that are available to those of you who may have clients or may personally wish to invest in the United States or engage in trade with the United States to obtain investor visas. The company transfer visa, which is the L1 company transfer visa, looks relatively straightforward, but is quite complicated actually. And then we will touch on a few of the green card options and the EB-5 investors. Quite directly, each one of these topics could be at least an hour or two to even get into it, so please excuse me if we merely touch on the basics and give you some idea of the outline of these particular visa categories. Again, you can reach us. And by the way, we have regular webinars. If you go to wolfsdorf.com, free webinar, you can see our schedule. On May the 17th, we will have a webinar focusing on religious workers, which will be delivered by my colleague Cliff Rosenthal, very, very knowledgeable in the area of religious workers. And we have an additional schedule coming up of other programs for students, welcome again. If you are comfortable and you enjoy the program, please take the time to like us on Facebook. You can also follow us on Twitter at twitter.com/Wolfsdorf. It may appear that I am trying to kill time, and the answer is I actually am. And the reason is very simple, is that folks often take a few minutes to log on, and I'm just watching the numbers as people give them a minute or two to get on. Not everybody is as punctual as you folks have been. So welcome again, and again focusing on the treaty investor. Now, the very important point to note with regard to the E1 or the E2 treaty investor is that you have two basic types of treaty trader and treaty investor visas. There must, of course, to start off, be a treaty between the United States and the country of nationality of the foreign national. Now, there are approximately 80 countries that have the treaty. Some of them are only treaty trader visas. Some of them have an option of both E1 and E2, so you have the choice to choose if, in fact, the individual or the activity qualifies for both. In order to qualify under the treaty investor category, at least 50% of the company must be owned by the treaty country national. So if the company is 50% owned by German citizens, that company can, in fact, qualify for a E2 or E1 treaty trader or treaty investor visa if the company is at least 50% owned by that particular national. Now, the person must be coming to develop and direct the operations of an enterprise in which the national has invested or is in the process of investing a substantial amount of capital. We'll get into this in considerable detail, but the four key elements that one needs to deal with, of course, is that there is in existence a treaty between the country of nationality and the United States. There's many different types of treaties, but the basic treaty, some of the investor treaties do actually not give visa options. So the first question, of course, is does a treaty exist? The second question is does the person have the correct nationality? The third question, of course, is the individual going to engage in trade, which is E1, or only in investment, which is the E2? And then the question, of course, is the person coming to invest in a qualifying, or is the person, in fact, going to work in a qualifying capacity such that they would qualify for that visa? So, and of course, by the way, the national coming in must have the nationality of the treaty country. So if the country is 50% German-owned and the person seeking the visa has to be a German national, if the individual is an Austrian national, then they cannot qualify for that E2 visa as a principal. If the spouse, of course, is qualified, then the spouse can get the E, and the non-working spouse can also acquire the visa, even if they do not have the appropriate nationality. So just briefly touching on the question of E1 treaty trader, 50% of the trade must be between the treaty country and the United States. Now that's a very, very important issue because today, for example, there may be a lot of manufacturing in China. So if the owner of the company is 50% German and they are doing more than 50% of the trade with China because the goods are manufactured in China, that may disqualify the individual. The trade has to be between the United States and the treaty country. The second issue, of course, is that the E2 investor visa must be substantial. These are complicated words. What is a substantial investment? We'll go into that in a little bit of detail, but it's actually relatively complicated. Usually substantial is evaluated in terms of the amount of money necessary for that kind of business. So substantial to manufacture automobiles may be millions and millions of dollars, whereas substantial in order to run a restaurant may be, you know, as little as 150, 200,000. So again, the rules will vary based on the specific nature of the investment. Now, can a startup company qualify? Yes, the answer is a startup company can qualify. The individual, of course, could also buy an existing company and still qualify as well. So many of the big multinationals that we see that are German-owned or Japanese-owned, for example, may qualify. You notice I haven't used the word Indian-owned or Chinese-owned because there's no treaty with China. The treaty, in fact, is with Taiwan, but the People's Republic of China does not have a treaty. India does not have a visa treaty, that is, or a treaty that will qualify individuals of that country for E1 or E2 visas. Now, the E2 can actually be the investor, but it can also be an employee of the multinational company. So the E2 can, in fact, be an employee, doesn't have to be the principal investor, and that person must come in an executive, manager, or essential employee capacity. Most of us know what an executive or a manager is. The concept of essential employee is quite a complex topic, and it really means what it says, but some people forget what the word essential is, and sometimes problems in fact develop in that arena with regard to qualifying essential employees, that they are essential and that there's no U.S. worker who could basically do that job or be trained to do that job. Now, one of the things I'm going to talk about, which is a complex issue, which is whether or not to apply for an E1, E2 treaty investor, or whether to apply for the L1A, which is the managerial executive transfer, or the L1B specialized knowledge transfer. Very often there's a choice. The foreign national may in fact qualify for both E1, E2, or L1A or L1B, and of course the critical element is to make sure that one chooses the best option, even though there may in fact be two visa options available in this particular situation. So we'll go through some of the issues and some of the choices that will help you make the decision if in fact you're in that position and you wish to consider making an investment or a specialized or be transferred as a specialized knowledge transferee. One of the so-called advantages of coming in under the L1A, that is the managerial or executive transfer, is that under certain circumstances that person may qualify for what we call an E-13 managerial or executive green card. So if the long-term goal is in fact to obtain permanent residence for that manager or executive, and the person may in fact qualify, then L1 may be an appropriate option over an E1, E2, although interestingly, and some people don't know this, that an E2 or E1 manager or executive, if they meet the requirements for the executive, the E-13 green card, they can in fact flip from the E2 through to the E-13, although that is sometimes more complicated and a little bit more difficult to prove because the L1 requirements are often very similar to the executive or managerial green card requirements. Now, one of the very, very positive aspects of the L1 company transfer visa and, quite frankly, the E visa is that the spouse and children will also receive the derivative visa, which is also called an E1 or E2, and the spouse can apply for a work permit, which is an open market work permit that is an unrestricted work permit. This is a huge advantage. It's a relatively recent change to the law that allows spouses of L visa holders and spouses of E visa holders to in fact apply for a work permit. It does take at least 2 or 3 months to process this work permit. It's not automatic, but that work permit is unrestricted in terms of the scope of employment allowed for the spouse. So the good news again is that spouses of L1s and E2s investors can in fact obtain work permission. Children are merely allowed to be present. That's children under the age of 21, by the way. That's an age out. If the child is over 21, they do not qualify. And at that point, the children, of course, can go to school, they can study, but they are not authorized to be employed. Moving on to the list of countries, this is a fairly expansive list. I am referring here to the State Department Regulations 9 Foreign Affairs Manual 41.51. It's also 22 CFR. But this is the, if you simply Google this 9 FAM 41.51, Exhibit 1 will provide a current list of all the countries, many of the European countries, some of the Asian countries, some of the South American countries have Canada, Mexico under NAFTA, many different countries. As I say, the last count is approximately 80 countries have treaties that will allow the individual or the national of that country to make a substantial investment or engage in substantial trade with the United States, resulting in the visa issuance. So if you check that list, you can find out if in fact your nationality or country is in fact eligible for the E1 or E2. Now, let's touch on the question of what sort of things can be traded to satisfy substantial trade. I keep quoting this Foreign Affairs Manual. There is, of course, CIS, which is Citizenship and Immigration Services. They also have regulations, separate set of regulations, by the way, covering the same topic. But I'm going to primarily refer to the State Department regulations. I find them extremely well written, extremely clear, and these regulations, and I'm giving the regulatory site, will in fact clearly explain what these concepts are. Unfortunately, in this relatively short time, I won't be getting into depth on many of these issues, but what sort of things can be traded. Basically, both services and technology can be traded, not just goods. There's a broad range of things that can be traded. Of course, it's more difficult when it comes to services, technology. How do you quantify the value of those? So that can be quite difficult. I'd mentioned point 2 already, that more than 50% of the total trade must be between the two countries, and this is a very, very major stumbling block for many countries because the trade often the goods are manufactured elsewhere. When we come to the volume and value of the trade, both of these, quite frankly, count. We want to see that there's a substantial volume of trade, regular and systematic, and that the goods or items being traded, in fact, have a substantial value. So simply shipping one crate of wine from Italy, unless it's a very, very big crate, is just simply not going to cut it. For an E1, you would have to have a regular and systematic shipment of wine product from Italy, assuming you're an Italian national and you are importing wine to the United States. That may qualify you if you can show regular and systematic trade. So one of the interesting things is, can a small business ever satisfy substantial trade requirement? And interestingly, the regulations are reasonably generous when it comes to relatively small amounts of trade. In fact, more so than in the case of the E2, which requires substantial. So a smaller volume of trade can, in fact, sometimes qualify without a substantial investment, but the requirement, of course, is that there must be a regular and systematic transfer of goods or services, as it were, if the individual is going to qualify under the E1 for the E1 visa. So the amount of trade is a critical issue, but in some instances, a small business can satisfy the trader requirement. One of the very important requirements, and you'll see similar, I keep repeating a lot of the same points because you see similar language in different areas of the law. The applicant must be employed in a supervisory or executive capacity or possess highly specialized skills essential to the efficient operation of the firm. So regular skilled or unskilled workers simply do not qualify. Consuls are generally quite strict in permitting ordinary skilled or unskilled workers to come in. The individual does have to have either supervisory, executive, those are very specialized terms, or possess highly specialized skills in order to qualify. Now, some of the issues that we face in the E2 investor category is again, a lot of these things are quite complicated. I'm going to try and make them simple. I'll just touch on them in the brief time we have. But how can an individual show that the investment is at risk? Now, this concept of being at risk is a very, very important concept when it comes to the E2 visa, and the government wants to basically be able to see whether you're going to be able to lose your money, as it were. So if you just transfer $500,000 and put it in a bank account, or just buy a building and there's very little risk, so-called passive investment, that is simply not going to qualify for an E2. You want to be able to lose the money. You have to really put it in a business. So can a bank loan qualify as an at-risk investment? The rule's a little bit complicated on loans, but generally the loan has to be secured by the individual's personal assets as opposed to the assets of the company. So loans can be an issue in relation to the E2 visa. Here's the most important point from at least my perspective. How can an individual show the investment capital is irrevocably committed. This is one of my favorite phrases when it comes to the E2, which is how can we show that the investment is irrevocably committed. What that basically means is that the person cannot just put the money into the company, get the E2 visa, and then take the money out. They want to see that the money is irrevocably committed. The other word that my favorite word on this one is called spent. We want to see receipts. We want to see commitments. We want to see that the person, if the amount of investment is $250,000, they want to see that a very substantial portion of that amount has in fact been spent, so that it is irrevocably committed, and the person doesn't just get the visa and then turn around and leave the country, or just use the visa and not be directing and controlling the commercial enterprise. Retained earnings. Now, there's a few complicated terms, but the general rule on an E2 is that retained earnings are not permissible in terms of, so if the company starts off very small and grows over time, the retained earnings in the company cannot generally be used to qualify that company for an E2 visa. There are certain circumstances, perhaps, where the money is taken out, taxes are paid, maybe if there was a new commercial enterprise started, that retained earnings, in fact, could be used. Simple bottom line, again, is have we made a substantial investment in the company, put the money at risk, and is that money irrevocably committed into a real commercial enterprise that is basically going to benefit the United States economy and create jobs for, quite frankly, Americans. So the consuls are going to look at this from a practical point of view, look at this person standing in front of them. There is a personal interview required for these visas, and has to be convinced that if it's a principal investor, this individual is actually made a substantial investment in the business, or in the case of an essential employee, is this person truly essential and so unique that an American couldn't be hired to do this job if it's an employee situation. So I'm going to talk a little bit more about substantial investment, because it is the big issue. I always get that question. How much do I need to invest? Is it $50,000? Is it $60,000? Oh, and by the way, I see questions are starting to pop up, which is wonderful. Thank you. I'm delighted to see the questions. I may sort of, just to break them, what can I say, monotony of my presentation. I try to be a little silly from time to time to do that, but I will maybe just jump out of place, read some questions, and answer them. So those of you who are computer savvy, please use your chat column. Love answering questions. This isn't legal advice, although of course I am a certified specialist. Well, I am a certified specialist immigration attorney, sorry, a little technical snafu there, but we're fine. Very good. Oh, okay, here we go. Are you going to share this presentation afterwards? The good news is yes, I am. I'm going to maintain confidentiality, but after this webinar, we're going to send you out an email, and we will share this presentation with you. In fact, this webinar hopefully will be recorded, and you might even be able to, actually, I don't want to have you switch off right now, but you can have your friends log on and listen to it. And it should be available online. But again, I will qualify and say this is not legal advice, but we do like to share the presentation, share the slide presentation, and hopefully you will get something valuable out of it. So we're talking again about what is a substantial investment. Interesting thing again, no specific minimum investment. It's determined by the proportionality test. That's the amount in relation to the total cost of purchasing an established business or creating a new business. Let's put that into a common sense situation. What is substantial? You know, again, if you're going to manufacture supersonic aircraft, it probably could be hundreds of millions or maybe billions. If you're going to simply run a restaurant, maybe it's 150 or 200,000. You have to show that that is a substantial investment in relation to that type of business. I like to use business plans, sometimes reports from chambers of commerce and other areas, or experts will also help, not always required, but we tend to over-document our cases. Now, this is a very important point. The magnitude of the business must be sufficient to ensure the applicant's financial commitment to its successful operation. Okay, so what I do here, I put up a good business plan. We want to see that this is a properly funded business. Everybody knows it's quite hard to start a business. A lot of businesses fail, so you need to show that that business is adequately funded for that type of company. And this is the question that I get constantly, and there is no one answer. It is a value judgment, but most of the consuls are quite good, quite strict actually, in interpreting this. The amount, of course, will vary from place to place and from individual to individual, so there is no fixed amount. People used to say, is 100,000 enough? I often try to push people to 150, 200,000, but I do hear stories of visas being issued in lesser amounts and possibly in the high tech. We always like to remember that Microsoft was started off in a garage, and Google and all these companies started off with very small investments, but quite frankly, you're going to have some problems if you don't have a very good business plan if it's only a $10,000 or $20,000 investment, because that is often deemed to be a marginal investment. That's the bad word, marginal. It's just not enough. The Department of State will use a two-part test. I keep quoting to the citation here. Does the foreign national's income from the investment exceed what is required to support themselves and their family? So the question here is the business plan. Let's assume that this family requires $50,000 a year to live, and let's assume that the business is making $60,000 a year, or that's the business plan. You probably don't have an E-2 because it's just not going to work. They want to see that it's going to be substantial, more than enough just to support the principal investor if that's an E-2 investor visa. What is the capacity of the enterprise to make a significant economic contribution and expand U.S. employment? This is the biggie for me, that the business, in fact, is going to make a significant economic contribution. Okay, so, we've got another shoe shine business just opened up, and, is that, I think we need shoe shine folks, but the simple bottom line is that may not be deemed to be a significant economic contribution, although the truth is I'm not good at shining my own shoes, so I fully understand the importance of having that. Maybe we should set up a chain of shoe shine operations throughout the United States, have them well funded at every single airport, and that may in fact be a new E-2 treaty investor visa. But the question, of course, is the person doing the job essential or managerial? Maybe if you were running the business, but certainly that would appear to be unskilled labor, and you wouldn't be able to bring in people. I'm not sure. I just made that one up. I'm not sure that one really works, but hopefully it's a little bit amusing. Anyway, moving on, this is another critical point for the E-2, and I guess I should be watching my time. The applicant must be in a position to develop and direct. All these funny technical words. What does develop and direct mean? Well, it's quite simple. The American consul looks at this 19-year-old kid who says he's going to do this business and says, I'm going to manufacture, I'm going to do this, I'm going to do that. We all know how hard it is to set up a business, and the officer has to be convinced that this is a genuine business, and this individual is genuinely going to develop and direct. This is not just some trick to get a visa to come into the United States. So that's a very important point people need to understand. Oh, I just got denied. Well, your business plan was good, your investment was good, but the consul just didn't think that this individual was the right person to develop and direct the commercial enterprise. So if the applicant is not the principal investor, I've said this before, I do repeat myself occasionally, he or she must be employed in a supervisory, executive, or highly specialized skill capacity. These are very complex terms. I've already mentioned ordinary skilled and unskilled workers do not apply. Now that you're starting to understand everything about an E-2, let's start getting you a little bit confused. One of the biggest problems we have is people don't seem to understand the difference between a status and visa. So I'll spend 15 seconds, because this is a basic entry-level presentation. If you came to the United States on a B-1 business visitor visa, for example, in order to set up the business, to incorporate the company, to maybe sign some contracts, you're not allowed to work, but you are allowed to use a B-1 to set up the business, fairly narrow. You can hire people, but you can't be employed. That individual could technically apply for a change of status with USCIS and could be approved for a period of 2 years. I've seen people come in on B1s, get the 2-year approval, extend them, extend them, extend them. 8 years later, they've never traveled, and they've only filed with Immigration Service, and the Immigration Service has authorized that status, and that's a legitimate way to do it, provided, of course, everybody told the truth when getting the visa and they came to the airport, that that individual was really coming to develop and direct, scratch that, in order to set up a business visa. Now, if the applicant, even though they have this approved status from USCIS, from immigration, and they travel abroad, they do need to apply for a visa at a consular post in order to be able to freely travel, and that, quite frankly, is a brand new application. People get confused. The fact that immigration has approved you doesn't mean anything. They take that approval notice, they go to the consul, they say, give me a visa, they get thrown out, they are not happy. So very often I prefer to just apply directly at the consulate, get the visa to start off with. Otherwise, it quite frankly ends up to be twice the amount of work. Wow, we have an amazing attendance today. I need to tell you, we had several hundred, I won't exactly say how many, but an amazing turnout and registration for this program. So if you find it valuable, please do feel free to share it with your friends, and it should be online on our website. Feel free to follow up. Our contact information is available. The website is wolfsdorf.com. I know that's difficult to spell, but it's wolf like the animal with an S and then a D-O-R-F at the end. I'm going to throw out a little, answer one of the questions, because questions just break the monotony of my presentation. This is an interesting one. I just renewed my E1 visa in Mexico, and the consulate only gave me a renewal for 1 year because of the reciprocity. Now, that's a word I want you all to learn, the reciprocity with Mexico. Do you know something if can be done on this visa? Because my first visa was for 5 years, and I'm running a business, and blah, blah, blah. Oops, sorry, it's not blah, 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 but it's a very real problem. And here's the interesting thing. There are obviously a lot of Mexican businessmen being a neighbor, a lot of Canadian businessmen who invest in the United States, make substantial investment. These are the so-called NAFTA treaty. And if you look at the right-hand side of my little slide, you will see there that it says travel.state. Blah, blah. You know, you can just Google the term visa reciprocity, and you'll probably find that one. Now, always watch out for, at the end, it's travel.state.gov, okay? No @ sign, travel.state.gov. A lot of good information on the State Department website. And here's what happened. In the good old days, Mexican nationals used to get 5-year visas, and suddenly someone brought up the issue that the reciprocity, which is that the Americans going to Mexico only get 1 year FM, let me see if I've got it right, I think it's FM3s, that American equivalent has to renew their visa every year. So the way that State Department always works is reciprocity. So very contentious issue, but as a result, the reciprocity schedule was changed from 5 years to 1 year, and Mexican businessmen now have a considerable headache, quite frankly, because every 8 to 10 months, if they need to travel, they have to go through this process again and again and again, filling out the forms, paying the fees, going through it. And I wish I could tell you that I had a solution. Interestingly, 2 minutes before I started this webinar, I was meeting with a Mexican businessman, and I asked him, well, you know, you're a Mexican national. He said, yes, but I have a Spanish passport. And I'm like, wow, that is good news, because you are actually a dual citizen, and if you apply as a Spaniard, which has a 5-year reciprocity schedule, I'm going to be able to get a 5-year visa. And he said, well, does that mean I need to go to Spain? And the answer is, well, actually, maybe we have a choice. If, in fact, you live in Mexico City, you probably should be applying in your place of let's try one more time. Residence. Your place of residence is where consuls generally prefer. We do have a choice of where we apply, but the simple bottom line here is that nationality is very critical. And by the way, if you think 1 year is bad, I think there's at least 1 or 2 countries that have reciprocity schedules of only 6 months. So there's something even worse, but this has become a very big problem for Mexican nationals. But if you're a dual citizen or eligible for another passport, then you might in fact be eligible for a longer visa. You have to enter on that visa, you have to apply, scratch that, enter on that passport, travel on that passport, apply on that passport. But the U.S. government doesn't have a problem with the fact that maybe you have a different nationality. So sorry, sir, that we do have this problem. Oh, the questions just rolling in right now. Really interesting questions. I'm going to try and cover all of the topic. Fire away. Any question, any time. It'd be my pleasure to answer it. If I don't know the answer, I'll tell you. Sometimes I may guess, but I'll warn you if I do. This is not, of course, legal advice. I cannot formally give legal advice until it's a professional consultation and I know all the facts. It's what I call shoot from the hip and try and give you some guidance on some of these issues. Now, explaining the difference between status and visas. By the way, I don't always talk this fast. I just have a lot of material to cover and I'm having a good time here. On arrival, the individual is granted admission for 2 years regardless of the length of the visa. Now, I know most of you just kind of got most of what I was saying, and so let me try and confuse you. So let's assume now we have a 5-year visa because we came in on a Spanish passport, and we arrive at the airport, and the officer, we fill out our little white I-94 card, and the officer gives me 2 years. And by the way, always check that little white card because there's a lot of mistakes made. And the simple bottom line is, even though as a Mexican national, you, sir, may have a 1-year visa, when you arrive at the airport, Customs and Border Protection, the immigration officer at the airport, should give you a 2-year period of admission, provided your passport's valid, of course. But the simple bottom line is, every time an E2 visa holder enters the United States, they are granted a 2-year period of admission, even if they have a 5-year visa or a 1-year visa, unless the passport's about to expire. So the simple bottom line is, if you got a 5-year visa, and if you entered 1 or 2 months before the end of that visa, technically that single 1-year visa would allow, a 5-year visa would allow you to stay for a period of up to 7 years. Now, I know you don't want a math lesson. I'm sorry to bring in all the math and all the confusion here, but wow, the questions are just rolling in, so let me have some fun. Question number 3, and I haven't read this. Can someone on a J2 visa, that's an exchange visitor visa, switch to an E1 if one was working in the U.S. with a foreign company that just qualified for an E1 visa and has a managerial executive position? Now, the J2, which is a spouse of the J1, is one of the categories that does allow a person to apply for an employment authorization. And if you look at my little drawing here, that individual can switch from a J to an E, if, of course, they qualify for the E and get a 2-year approval from immigration, subject to one huge thing, and that's another whole webinar topic, is that you are not subject to the 2-year foreign residence requirement. So J is a very restrictive visa, so if you don't have that 2-year foreign residence requirement, you would potentially be able to apply for a change of status. Next interesting question. Boy, I'll just finish the whole webinar answering questions. Oh, now somebody's saying, what about an F1 to an E2? Anything, except the visa waiver program. And of course, you have to be in lawful status and you haven't violated status. But that's what my whole drawing is all about. You can always go abroad to a consul to apply for a visa, or you can apply for a change of status in the United States. Oh, talking too quickly. Getting a lot of questions on that. I checked my country's name in the treaty. It is there, Iran. Could political conflicts affect me from obtaining an E2? Yes, and I don't know if it's a sir or madam, but yes, Iranian nationals are eligible for the E, but that is subject to sanctions. In fact, President Obama just stepped up sanctions on Iran. There's all sorts of sanctions now. If you go to another website, that's the Treasury website, and this is not a rude word, it's OFAC, O-F-A-C, the Office of Foreign Asset Control. That was not a good joke. OFAC, seriously, US, just Google that word. There's a separate page on Iran sanctions. I urge you to read it. If the money is coming from certain banks, it is very restrictive. We do Iranian cases, and there's a whole new thing emerging that you need to get a license. And those licenses are now taking forever. I've got one that's pending for over a year. They used to take 2 or 3 months. So you may need a license, but it's very interesting. There's certain goods that can be imported from Iran, but because trade with Iran is sometimes prohibited, that can impact. But the treaty with Iran is alive and well, but subject to sanctions, and we don't want to break those sanction laws because the punishments are very strict. Oh my gosh, the questions just keep going. What would be the case of an Iranian businessman who has residence of Sweden? I'm not interested in residence. I'm interested, and hi, I'm seeing all my clients here. Nice to see your name. Welcome. Some of these are my clients, some are not. But the simple bottom line is residency doesn't work. We're talking about citizenship. Citizenship. Do you have the passport of that country? Sweden does qualify, but they only have a 2-year treaty for some reason. It's from IMAC 90. Adjusting status to E2, overstay for more than 1 year. Is 212D3 available? Oh, yucky, yucky, yucky. The simple bottom line is, yes, there is a waiver, but if you just leave the country and trigger a bar, you have what we call a recency problem. You can't just overstay a visa and expect the consul to excuse you. But of course, if you broke your leg and you were in hospital and you were in traction and that's why you overstayed for you, of course this has to be true. You have to have a very compelling reason, quite frankly, because it's a balancing of interest. Money sources from property and I mean to invest. Yeah, sure, why not? But prove that the money is legal, particularly if you come from Iran. You know, they really want to make sure that this is legally sourced. Properties in Dubai, that's fine, you can sell it, that's not a big problem. So simple bottom line is yes, yes, yes. You can show that the money was earned by selling property in Dubai. That may not, I'm not going to give an opinion on sanctions, but that's starting to look good. It's in my absolute pleasure. I'm getting a thank you for answering that question. On arrival, granted admission for 2 years. I better keep going, but I must tell you, e-visas are wonderful. Now, intention to depart. This is kind of an interesting question. Yes, the individual must have the intent to depart upon termination of status. This is kind of relatively soft because even if you filed an immigrant visa petition or green card, you are not necessarily barred from obtaining an e-visa. So, but the person does have to make, here's the magic words, unequivocal intent to leave. So we always put in a statement and an undertaking that the individual plans to leave the United States at the end of the E2. But I have one client, I think they've been on an E2 now for about 20 years. They just keep extending and extending. So I could probably carry on for another hour or two on ease, but I just wanted to let you know that this is a good visa. Make a substantial investment in the United States. Make sure it benefits the United States, and you'll probably be able to get your visa. Wow, I've been going for almost 45 minutes. I talk a lot. Okay, so let's talk a little bit about the L1 intracompany transfer visa. Two types here, the managerial transfer for executives and managers, and then, of course, we've got the L1B specialized knowledge requirement. I don't like the L's as much as I like the E's, but everybody's got their personal choice. One of the requirements is you have to have 1 year of employment with the overseas company. So that 1 year of employment has to be in a manager, executive, or specialized knowledge capacity. If you haven't been working for the company abroad, then that individual is not going to be able to qualify. And again, kind of similar language here. Look, executive, managerial, or specialized. So suddenly we went from essential employee to specialized knowledge, very complicated topics, pages and pages, but basically this is going to have to be a pretty unique position for the individual to fill. One of the interesting things about the L1, this can be authorized for a period of up to 7 years. There's exceptions for people who are outside recapturing time, commuter visas. And the L1B, the specialized knowledge one, is good for up to 5 years. So if that's the maximum period of time, a new office L is approved for 1 year, then you have to get the extension. Those are difficult to get. If it's already an established company, the L1A or the L1B can be approved initially for a period of up to 3 years. Again, the spouse and children are scratch that, entitled to receive L2 visas. Children can study. The spouse can Spouse can in fact apply for a work permit, so the employment authorization card. And here's the wonderful thing: the L1A can sometimes apply for a managerial green card, the fast-track green card, the EB1, the EB13. This is a really wonderful thing, but you can in fact switch it off the E2 as well if you meet all of the criteria, the government criteria. Now, let's briefly talk about a blanket L1Z. If any of you out there represent Here's an interesting question. Can someone after a time go from E2 to green card? Yeah, that's one of the disadvantages. It's kind of hard, but we're going to talk briefly about it, is that if the E2 meets, and I'll flip back to the last slide, if the E2 meets that bottom criteria, the EB1 criteria, so the person could have got an L1 and qualifies under the EB1, which is the sort of managerial transfer, then they can in fact switch from the E2. So let me put that another way. You're a German businessman, you own a big company in Germany, you own a big company in the United States, you have 25, 30 employees in the US company, you came over on an E2, there's multi-layers of employees, and I'm going to repeat that one. We've got an organization chart, an org chart that shows 2 or 3 levels of employment. That's my favorite word, by the way, for an L1, org chart and tax returns. Those are my 2 favorite documents. I drive all my clients crazy. That is well known because I need my cases properly documented. But if the person has an organization chart, which is in a pyramid showing several layers of employees, that individual may be able to switch over from an E2 to a green card. But it's not an easy process. So let's keep going. I'm now talking about a blanket L1Z. This is really just for large companies, and the nice thing about this is the person can apply directly at the consulate. There's the requirements. They must have 3 or more domestic or foreign branches. These requirements are not as strict as people think. Either they have 10 approved L1s in the past 12 months. Requirement number 2 is the one that usually works best if the subsidiaries or affiliates have combined sales of 25 million. So subsidiaries or affiliates, so the worldwide group has 25 million in sales, 3 or more branches. You may have a blanket L1Z, and this is a way to apply directly at a consulate. A lot of companies don't know about this L1Z. The truth is it's one of my favorite visas. Consuls are relatively strict on issuance, but the good thing about this is speed. These things can be processed very quickly, sometimes in only a few days. Other non-immigrant visas, I just threw this in. There's a religious worker. Why did I throw that in? I don't know. J1, interns, trainees, foreign degree or experience. If they have a foreign degree or 5 years of experience coming in on a J1, I see one of the people in the audience has a J. That's an exchange visitor visa. They can come in, very popular program. There's other trainee visas such as A3s, but this is now off topic, but I just want to let you know that there's a whole slew of work visa categories all the way through from the A visa, diplomatic visa, down to STU visa is the current one at the lowest STU visa. It's the U visa. So a whole lot of other visas. One of them that I actually like to mention for businessmen, because it is possible, is the alien of extraordinary ability. You are very, very, very good at what you do. We just did a blog yesterday. Is everybody at the Olympics qualified? I don't know that you participate in the Olympics that qualifies you as an extraordinary, but it sure would be a good one. If you're a gold medal winner, you almost certainly are an alien of extraordinary ability. That would be, of course, in the sports. That falls under arts. But you will notice that this category also includes an alien of extraordinary ability. Don't you love that word, alien? Alien of extraordinary ability in business would qualify. And just going through these categories: major awards, commercially successful, high compensation, original contributions, key roles. So we do file quite a few O1s for extraordinary businessmen, and that seems to work quite well. Just want to mention it. Don't want to get bogged down with it. I'm watching my time here, and gosh, I talk too much. Immigrant visa, green card options, employment-based first preference, employment-based EB1, alien of extraordinary ability. Bernie, will you stop repeating yourself? Didn't you just say that? O1, alien of extraordinary ability, and now we're talking about a green card for alien of extraordinary ability. Well, let's assume that I am a Steve Jobs type of guy. Okay, we don't have to go that high, but I'm a Steve Jobs kind of guy from Germany or France or Iran or any other country, and I'm just extraordinary at what I do. I can actually self-petition for a green card all on my own, no employer, and if I can show that I will contribute to the United States, that is a requirement, I can qualify as a first preference green card, and we normally start to finish process those cases in as little as a year. So extraordinary ability is something, but folks, you really got to be extraordinary. it's a very, very high standard. Also available for researchers and professors. But the reason I put that in is because there's 3 categories of employment-based first preference, and the one that I'm talking about today is the multinational executive or manager. I've said it about 3 times, but why not try 4? This is the individual who is managing a large company. So we have, IBM Europe, Germany, or something like that. We have IBM USA, and I was a senior manager over there, and I'm coming over as a senior manager over here, and I get an EB1, EB13, sometimes EB. But the simple bottom line is that individual can convert over to a green card. So employment-based green card, employed abroad for 1 year. Again, you must have that employment abroad for 1 year in the 3 years preceding the transfer in order to qualify for the L1. And then once the company's been doing business in the United States for a year, you can convert that over to a green card. I should probably talk a little bit slower. Seeks to enter the United States to continue in a managerial or executive knowledge. No specialized, no L1B here, but the manager or executive can, in fact, get a green card without going through a labor certification. Now they refer to it as PERM. PERM is when their Labor Department is certified there's no U.S. worker to do that job. So this is for a managerial or executive transfer, and that is a green card that is available for senior managers with a big org chart, probably a nice tax return as well to show the company is viable. Just briefly talking about others, this doesn't really fit in, but for those of you who are sort of beginners in this, EB2 second preference, advanced degree, master's or higher, or a bachelor's degree plus 5 years. That is another category of EB2. There's also a Schedule A Group 2, alien of exception ability in arts, sciences, or performing arts, does not include business. And then, of course, there's a national interest waiver, which is another whole webinar topic. If you can show that your work is of intrinsic value to the U.S. national interest, and it's of broad application, not just local application, that's a fairly vague standard, but if you have a master's or advanced degree equivalent, you can, in fact, self-petition for the national interest waiver. That's second preference. If you're born in India or China, there's a waiting line. Other countries don't have it at the moment. EB3, so I spoke about EB1, the managerial transfer. EB3 is the third preference category, current waiting line, 6 or 7 years at least for professional, skilled, and other workers. This is through the PERM process, where the Labor Department has to certify that there's no workers. This is employment sponsored. Quite a few questions here. Let me shoot at them. Hi, can I convert to an L? Well, if you're in valid lawful status at this point, yes. And if you meet all these requirements, that is that you have worked for the overseas company for at least 1 year prior to the transfer, and the companies are appropriately affiliated. Let's see this next question. Is there a path for a Canadian who gained a PhD in the U.S. to parlay this into green card? I love that word, parlay. The simple bottom line is that, yeah, you may be an O1 type of person. You may be an extraordinary individual. You've got a PhD, so has my wife got a PhD. She's much smarter than me. That's not saying a lot. But the simple bottom line is that PhDs, how many publications, it's not that simple. Just having a PhD alone won't do it. But you may be a starter. U.S. does like qualified individuals, but you'd have to be super, super extraordinary in order to self-petition, and you also have to show that you're going to be contribute to the economy of the United States. Needs the employee to have a master's degree before we start recruitment and the PERM process. Yes, if you're going to put in, if you're talking about second preference, you have to have that degree at the time the application is filed. At the time the application is filed, not necessarily at the time of the recruitment, but certainly by the time the application is filed, the foreign national has to have all of the requirements. Lots of technical questions here. Hello, how to start the skilled, I'm missing this. Skilled, there may be a typo here. I'm asking for an EB2 business. I'm struggling with the question. If you could restate it, I could probably get it answered. Sorry, I just can't read. Skilled, something in EB2, national interest waiver, but that's the PERM process. You need an employer who's going to sponsor you under the EB2 category unless you are going to be a national interest waiver case. Not so easy, but you have to show that you have made an intrinsic contribution of interest to the United States. Just talking about a few others, EB4, EB5. EB5, we actually did 3 webinars on the EB5 category alone. So just note, we did EB1, which was the managerial transfers, the extraordinary individual. We did EB2, which is the master's degree or bachelor's plus 5. You can self-sponsor if it's national interest waiver, or if you have an employer who can prove that there's no U.S. worker to do the job, you're in a unique sector, then you can maybe get an EB2. EB3 is only the bachelor's or lower degree category, long waiting line, 6 or 7 years. EB4, not much of a waiting line at the moment. This is religious workers, religious occupation, ordained, but that requires sponsorship, and the government is very strict. They want to make sure that you really are doing that work. So you have to be doing the good deeds of whichever religion you are involved in. $1 million investor. Everybody loves this one. This can be reduced down to $500,000 if it is in an area of high unemployment. That's defined as 150% of the national average, or in a rural area. These are very complicated definitions. The basic program is the employment creation program. We're really talking here about job creation. People seem to forget, they keep thinking of the EB5 as an investor visa program. It is an investor visa program, but it is also an employment creation program. So the EB5 program, very simply, there was a pilot program that everybody knows the term regional center right now, that emerged out of the original EB5 program from IMAC 90. That is a very, very old program. What are we at now? We're at 20 years into this program, and the program was created by President Bush Sr. in 1990, and this program will allow people who've made $1 million investment, that can be reduced down to $500,000 if it's in a high unemployment area or in a rural area. Rural area is quite narrowly defined, and they must create 10 full-time jobs. That's the regular and standard EB5 program. So again, the investment may be as little as $500,000 depending on the geographical area. I'm doing a very simplistic presentation on EB5 today. There's so many complex issues in this area that we could go for 10 hours and still not hit half of them. The investment must create 10 full-time jobs for U.S. workers, that is legal U.S. workers, in order to qualify. This individual through the EB5 program will get a conditional green card. It's only a 2-year green card, as if it was through marriage, and if at the end of the day the person can show that the investment is sustained, meaning that the money has not been pulled out basically, and that the jobs have been created, the conditional nature of the green card will be removed. So in real life, what we find, I mean, a lot of cases we're just getting approved now. Quite frankly, we're 4.5 years ago. This is a long process. I just called up a client very recently and said, "Great, the condition's been removed. I thought you'd be happy," and she complained to me, "Why was it taking so long?" So just need to warn everybody that this is a lengthy process, and it's not an easy process because the government is quite strict in terms of adjudicating and making sure that people comply with the rules, and you really need to be very cautious. I tend to be very cautious in the EB5 program. So what's the difference between an individual, traditional EB5, the good old EB5, and the regional center EB5, or the pilot program, which, by the way, expires on September 30th. Everybody says, oh, it's just going to get extended, but over the years I've had many, many nervous moments waiting for Congress to extend it. Hopefully it will be extended, but if not, wasting your time by talking about the regional center program. So do need to know that that extension needs to come up very soon. Sorry about the simplistic presentation on EB5 today, but we're just touching on this as one of the options that are available. Investor buys a business or starts a new business. Very, very simple.
a foreign investor comes over, buys a business for $1 million, or if it's a high unemployment or rural area, $500,000, or starts a new business, if they buy an existing business, very, very careful, because showing that you create 10 direct jobs, kind of want to see new employees. If that business wasn't a trouble business, sometimes you can show that you've saved the employees, but the simple bottom line is they want to see job creation. This individual EB-5 program isn't that popular. There are 10,000 visas a year. Only a very small percentage of that actually goes to individual EB-5s. Regional Center EB-5, what is a regional center? Basically, it's a specific approved geographical area covering certain types of industries. Some of these are so big, the state of Florida, the state of Hawaii, state of Vermont is a regional center. Government tends to be more restrictive right now in approving smaller regional centers, maybe a county or two, but the statistics, and this is a guesstimate, is that over 95% of the EB-5 cases are going into the regional center, because generally speaking, if the regional center is in a TEA, targeted employment area, which is 150% of the national average of unemployment, or rural area, the amount is reduced down to 500,000. A huge increase in the past 3 years, 194 approved. I think the government website says 212, but some of those are multiple. So I think the correct number is still under 200, but it's not that important. Huge choice. How many are there going to be 5 years from now? I don't know. Some of these businesses are failing. Some of them don't even have projects. You know, just be very, very careful. The word is due diligence. Please do your due diligence before you invest in your regional center. The main advantage of the regional center is that it may permit indirect employment counts. So instead of showing 10 full-time employees, we're talking about 10 indirect employees, even induced jobs. That is a very complicated concept, and sadly I'm not going to spend a lot of time talking about what constitutes indirect employment, but we are talking about the use of econometric models. We are talking about inputs and output models, which in fact will show that the jobs are being created indirectly. You may have heard of the latest hot issue, tenant occupancy issues. You know, if you're developing a particular area or a particular business, can you in fact count tenant jobs within that development? And the question is, maybe under certain circumstances, but you have to show that there's basically a new job creation. So not spending a lot of time. Which type of people may like this? This is a very long list, but sometimes it's parents of children who want to go to school in the U.S., retirees, huge big list of people who may well qualify, doctors, graduates, but basically anybody who can show clean money. I haven't emphasized the need for source of funds and the path of the source of funds, but showing that that money was legitimately earned and is in clean money is a very, very important requirement of the EB-5 program. Folks, I'm going to try and answer a few questions just so that everybody who asked a question is going to get it answered. Now, so I'm going back. For the EB-3, do we need to have a BA? The answer is no. No, you don't. Generally speaking, for the third preference, you need to have an employer who can show there's no U.S. workers. You generally have to be legal if you're going to be adjusting status, or you have what we call 245I protection. But simple bottom line is 2 years of work experience may well qualify you for an EB-3. That's 2 years in the appropriate category. There's also an EB-3 other worker category, which doesn't even require 2 years of experience. That is fairly limited numbers. Only 5,000 a year are afforded. California is a 500,000 EB-5 target today. No, that's too broad. You know, it really depends. We do have a lot of high unemployment in California, so many areas in California may qualify as a targeted employment area, but that is determined basically by evaluating the specific tract. It's just not that simple. Keeping on with answering all these good questions, could a national interest waiver apply towards an E2? Absolutely yes, but it's not that simple, because if you're on an E2, you're simply going to have to show that what you're doing is of intrinsic value to the United States. So yes, an NIW could be applied from an E2, but we have to show what is this huge contribution you've made to the economy. So again, your name was Steve Jobs, and you started a little company called Apple. I think there's a national interest waiver there, but you know, that's a little extreme. What's the date of the webinar for students? Oh my gosh, you have to go online to our program. Just go on to wolfsdorf.com. The webinars are all on there, and you'll see the upcoming series. We at least scheduled through till July that talks about student options, graduating student options. We should even have recordings of those webinars that talks about transition from F1, F1 OPT, H1, and talks about all the various options. But some of these options might also be available to you right here. So those are also available to you, is things like the E2, etc., etc. We're talking about other green card options briefly. I'm sort of jumping a little bit all over the place. Why not make sure that you get a whole lot of information about the visa options? It's very important to understand that there are a broad range of visa options available. Today's topic is primarily investor, the E2, my favorites. The L1 company transfer, we're going to talk about green cards for managers. We already went through that. And I very briefly touched on the EB5 investor program. Very complicated, very popular, but I'm warning most of my clients to be very, very careful before they move forward in that particular area. So the gentleman from Mexico had a follow-up question to renew your e-visa from Mexico. I don't want to renew my visa every year. This is common. What if I don't renew the visa one day and close the business? Well, you better keep extending. If you want to travel, you have to get that visa stamp. So that's the problem. And if you close your business one day, then you're going to, quite frankly, be undocumented, and that's not a good thing. So what you may want to do if you have an e-visa, if you've built this business up, and I spoke about retained earnings, but let's suppose your business is very successful and you took out $500,000 from that business and it was lawfully earned, and you put it into a regional center investment, or in certain circumstances you can even convert an e-visa into a green card. Again, be very careful of the retained earnings issue, because the money has to come out, pay tax on it, and then make a substantial investment. What is the best way? Oh, this question, I hate this question. What is the best way to identify a legitimate EB5 project? Oh, I just knew I was going to get that question. How do you choose from amongst the 194 regional centers? Half of them don't even have projects. Which ones are, okay. No, I'm glad you asked the question. It's a very good question. The word is called due diligence. You know, substantial businessmen, generally speaking, or businesswomen, before they make a substantial investment, they do something called due diligence. So you do your research. You use a financial analyst. You look at the risk factors. You evaluate the financial risk factors. You evaluate the immigration risk factors. Are there immigration problems? How many approvals? What is the track record? What are the financials? Who are these people setting it up? So if you were going to invest in a company, and I'm just picking on them, called Apple. Let's suppose you invested in an Apple computer 20 years ago. You know, you would be very rich right now, very, very, very rich. You know, did you know Steve Jobs? A lot of people have been believers in this guy for a long, long time. Or there was another one. What was his name again? Bill Gates. That's the one. Microsoft. Did you buy Microsoft? Did you buy Facebook? It's already too expensive. I think it's coming out. So, you know, who are these companies? Who are these people? What are their products? Examine their prospectus, examine their financials, financial analyst. Look at this not just as a green card option, because if the business fails, the green card can fail too. What's the track record of these people? Am I going to get my money back? And here's the favorite thing that I like to tell people. You know, when you make an investment, often you want to look at something called collateral, okay? You go to the bank and you ask for a loan. And the bank looks at you and says, wait a second, why should I give you money? There's no collateral. You're a poor guy. So banks want us to have collateral, and if you're going to invest in a commercial enterprise, you may want to make sure that that individual is going to have collateral. Oh gosh, now we're getting specific questions. Do you have any feedback from clients of your firm that invest in, yeah, I'm not even going to mention it, but it's one of the Vermont programs, Vermont Regional Center. You know, I'm a little bit scared to talk about specific. I just say that you always want to review the financials. I know there's been some questions about that particular regional center. You know, I know the guys. I think they're pretty reasonable. I mean, the track record looks good. You've got to study those financials. Study those financials. Ask your due diligence questions. They are one of the more established regional centers. I'm not telling the audience who I'm talking about because I'm sort of, I don't want to be saying anything other than nice things about everybody, but the simple bottom line is you need to do your due diligence. Be careful. That's an established program that we're looking at. I thought I could not deal with this webinar without briefly touching on family immigration. Family immigration is, what happened to my slide here? Are we frozen? Okay, so I spoke about family immigration. I'm just going to cover this very briefly in the minute or two that we have left. There's a green card lottery. If you come from Africa or Europe, they take most of the green card visas, 55,000 visas. Every year, that's in October or November. You probably don't need an attorney unless you have a complicated case, or maybe if you win, you need an attorney to be involved in the process. Relatively straightforward for most applicants. Family-based green card, immediate relative, spouse, of course, legitimate marriage, parent, or minor child of U.S. citizen. These are processed relatively quickly. I get this question every day, including yesterday. I have a child in the U.S. Can they sponsor me for a green card? Yes, when the child turns 21, if the U.S. citizen, they can, in fact, sponsor you. Let's keep going. Boy, who asked this question? Anybody would think I made this one up. How can I have your services professionally provided to me? Well, you know, our website is wolfsdorf.com. Our telephone number is 1-800-VISA-LAW. How hard is that? 1-800-VISA-LAW. Email is visalaw at my last name. Email us if we can be of assistance. If you have a legitimate case, give us a call. We are an immigration law firm, and this is what we do. We provide visa services. So I'm jumping all over the place, but I just want to make sure I finish all the topics, and I always love to make sure I answer every question. But there's a lot of news about scams in EB-5 projects. Oh, yes, there's always scams when it comes to EB-5. That's why I've been talking about please do your due diligence. Please do your due diligence. Please read the prospectus, read the private placement, read the financials, and even then that may not be enough. Use your common sense. Go out and inspect the regional centers because some of them, there have been a few issues with some of them, and you need to make sure that you have both good financial risk and that you have good immigration risk, because even if you get your money back, if you don't get your visa, that could be a problem. Here's one more L1 question. Individual obtains L1 status via parent company's blanket L1 and works for the affiliate. The affiliate is then spun off via an IPO and the qualified relationship no longer exists. What happens to his L status? Wow. This is a problem. You got a problem with a spin-off. The argument on an L is if it's a complex one, I have to look at it again. But if there is an entity to which the individual can be transferred back, then maybe they can keep L1 status. But before you do spin-offs, you should consult with a lawyer. This individual may need to switch to an H really quickly because the individual may have lost status. Does your firm provide due diligence in EB-5 projects? No, no, no. We're not qualified. We're just immigration lawyers. Yes, I'm a specialist in this area, but I am not a specialist. You have to find a financial analyst, a certified financial analyst who can do due diligence in your EB-5 project. And you need to carefully look over the prospectus as well. So I'm going to jump back to my family immigration. I'll do it really quickly. Unmarried adult child of a U.S. citizen, 6-year wait line. Actually, these numbers aren't even accurate. It's worse anymore. I guess I need to update this. The simple bottom line with regard to the unmarried child of a U.S. citizen, so if you've got a parent, long waiting line, pretty much long waiting lines for all of these categories. Like the bottom one, brother and sister of a U.S. citizen, says 11 years. It's really 12, 13 years. Married child of a U.S. citizen says 9 years. It's already 10 years. Unmarried child, adult child, 8, 9 years. And then the spouse and children, this is a little pessimistic. It's probably about 3 years right now. I always say probably because these waiting lines change. So having close family in the United States other than a U.S. citizen spouse generally isn't much good for immigration because you've got long waiting lines. Why am I throwing this in? Well, if you're on an E-2 visa, for example, and you get 5 years in your E-2 visa, and you've got to wait 9 years, well, then you renew your E-2 visa for 10 years. And, you know, let's suppose that you're on an E-visa and you have a brother or sister who's a U.S. citizen. That person can petition for you. You extend your 5-year E-visa 3 times, and you can get your green card through a brother or sister, or you can get a green card through the lottery, for example. So lots of different options to, in fact, obtain lawful status through family, but most of these are terrible waiting lines, and depending which country you're born in, it can be even longer. For example, Mexico or the Philippines, some countries have waiting lines that are just much longer than normal. So I don't know if that's a good picture of me. It looks a little bit old, but that's our contact information. I'm looking at my clock. I know that I've provided a lot of information. We've been going for an hour and a half right now. We have got an amazing attendance for today's presentation. There's my contact information. There's the firm's contact information. We have a New York office as well. If you enjoyed this, please take the time to, oh, somebody's saying thank you. How nice of you. Facebook.com/800 Visa Law. That's our telephone number. You can follow us on Twitter. There's a lot of immigration information coming up on a regular basis. There's our contact information. Oh, wow. Somebody says, thank you very much. You're an amazing, informative, honest, and fast talker. I try to give it clean. You're great. I want to thank you for all these nice compliments. Folks, we have regular webinars. Yes, we do like to claim to know what we're talking about. There's some areas that maybe we're not 100% perfect, but we do give straight answers. Very nice to hear from you all. We've been going for an hour and 45 minutes. As long as questions come in, I'm going to keep answering them. I wanted to continue to have my business open in the U.S. I'm on an E1, but it's risky to get only 1-year renewals. Do you know if there's some change? Again, the 1-year renewal is totally connected to the reciprocity schedule. So, you know, unless the country that you come from gives Americans a longer period, yeah, Mexico, unfortunately right now, unless they change the period of validity for the FM3, I think we're kind of stuck. If Mexico starts giving 5-year FM3s, then Mexican nationals will be getting 5-year Es from the U.S. That's what I spoke about earlier. We will be sending out this PowerPoint to all of you. It's been an absolute pleasure. I've covered a whole variety of topics in immigration law, everything from the E2, E1 investor visa, the company transfer visa, the green cards for managers, extraordinary ability, EB5 investors. The message that I'm giving you today is that somebody's joking they're going to talk to the Mexican president to change it. You know what? He could do it. It would be good for Mexican nationals as well. But the simple bottom line is that that is stuck by the reciprocity schedule. Again, I apologize for talking so quickly. I just wanted to cover this whole area. It's been an absolute joy to share. Wonderful to have such a large turnout. I can tell you there were several hundred people registered for today's program. Oh, somebody popped in another question, so they're coming. I've got my H-1B and green card by the help of your firm, which I appreciate. I found your firm honest, professional. Wow, thank you. Google Plus, go and give us a Google review. I'm getting all these things. I'm not making this up, folks. Here's a tough one that I'm not answering. What is a legal fee? We do discuss fees, but we have to know everything about the case. We try to do standardized fees. Some cases are a little bit more complicated, but we will give you written quotes for legal fees. Always a difficult one to do online, but simple bottom line is we need to evaluate your case, and then we will give you a fixed fee estimate. Thank you so much, everybody. Have a wonderful rest of the day. Oh my gosh, one more question. I'm going to take this as the last one. If you have overstayed in the U.S., do you still qualify for EB-5 or employment-based visa? Here's the simple bottom line. There's been a lot of debate about whether somebody is undocumented. In order to change status in the United States, you have to be legal. If you've been without status for more than 180 days, you can't change status. So you need to have Section 245I. So if you are undocumented, it is very difficult to acquire legal status. You need to be very careful. There's two views on this, whether an EB-5 who's undocumented can in fact get lawful status. I'm just going to tell you, be very, very careful. We'd have to look and see if you have 245I protection. And there's also the question of whether the money, if earned in the United States while you didn't have lawful status, is in fact lawfully earned money. So a lot of complex issues. Thank you so much, everybody, and look forward to being of assistance. Please go to our website at wolfsdorf.com. This will be repeated. We'll send out the webinar. And until next time, folks, wonderful participating in this webinar with you, and wishing you all a wonderful day. Thank you so much. Bye.